Thank you so much for joining us today at School Justice Project Summer Summit, a day of giving and discussion. We're so grateful to our sponsors, Alex Partners, the Russo Thompson family, Venable, Halo Top International, Mountain Shore Properties, Arnold and Porter, and Nixon Peabody for putting this day together. So today we'll be featuring a discussion with three of the incredible attorneys who are working on the Charles H. versus District of Columbia case. This case is a pending class action lawsuit against DC for failing to provide special education to students with disabilities who were incarcerated at the DC jail complex during the pandemic. Before we jump in, I just want to give any newcomers who are watching a quick overview of School Justice Project's work, just to put all of this in context. So School Justice Project, or SJP, is a special education legal services organization that works with court-involved students with disabilities, and mainly during incarceration and throughout the reentry process. We achieve our mission of ensuring that all students can access a quality education using a multi-pronged approach. So we have three strategies or programs. First, direct representation. Second, systemic advocacy. And third, legal training. So for our clients, getting access to education is hard enough as it is. There are very complex and deeply pervasive barriers to accessing a quality education during incarceration and throughout reentry. And obviously, the pandemic has only made these problems worse. This is a racial justice issue. 100% of our clients are students of color, 97% Black, 3% Latinx. 100% of our clients are students with disabilities, all of whom qualify for free legal representation. These are the students who were the hardest hit by the pandemic, and we saw firsthand just how devastating these effects were. So today we'll be talking about how we're using legal avenues to try to combat these injustices and mitigate the effects of the pandemic on court-involved students with disabilities. So I'm pleased to now introduce our wonderful panel. These are tireless advocates who have been working on this case. So we have with us today our very own Teo Bell, Senior Staff Attorney at School Justice Project, Caitlin Banner, the Deputy Legal Director for the Washington Lawyers Committee for Civil Rights and Urban Affairs, and Xenia Sanchez Fuentes, Attorney and Partner at Terrace, Pravlik and Millian. Thank you so much for being here today. And why don't we get started with some background? So Teo, I'm going to start with you. Can you give us an overview of the case and sort of a glimpse into how we got here today?
Of course. So first, just to put things into a little bit of perspective, 100% of the students at the jail who are in the high school program who are over 18 years old are students with disabilities. In DC, access to special education doesn't end until the end of the semester in which you turn 22 years old. So for many students, this is the last chance to access education before they age out of eligibility under the Federal Individuals with Disabilities Education Act, or the IDEA as we call it. So in March 2020, when DC declared its public health emergency due to the COVID-19 pandemic, people at the jail immediately felt the consequences. Incarcerated folks at the jail were put into a 23-1 lockdown, which means that they were in their cells for 23 hours a day with just 1 hour a day to leave their cells for things like personal hygiene or to maybe call their families. That included students, including the students who were previously attending classes in person at the jail in classrooms. In the community, the response to the pandemic and education was probably much like what you've heard or maybe experienced in your own family. Students were, by and large, given laptops, maybe tablets to do their work virtually through synchronous education provided by their school. They, still worked with their same teachers. For many students who received related services, such as counseling, they may have started receiving those services virtually as well. But still, the quality of the education, though there were hiccups in the beginning, by and large got back to as normal as could be, given the circumstances. However, for the students at the jail, our clients, no tech was given whatsoever. In fact, Wi-Fi wasn't even set up inside of the facility. Instead, work packets were provided to the students with no teacher instruction or feedback whatsoever, or any assistance at all to account for the fact that these are students with special education needs. In fact, some of our clients who were supposed to receive counseling as a related service receive work packets to write down how they were feeling and return it to the counselor in the hopes that that would actually allow them to somehow meet their counseling goals. So since October 2021, there has actually been a new school at the jail. It's no longer the District of Columbia Public Schools, but instead Maya Angelou Academy, a public charter school here in the district. And there have been improvements that we've seen and that our clients have felt. However, the obligations that are required under law, both the federal IDEA law and the local laws, are still not completely fulfilled. Our clients are wonderful clients who just want education during their incarceration. They just want the services and the instruction that they didn't receive during the pandemic, or at least something equivalent that would help them make progress in their education as per their individualized education programs, their IEPs. That might mean tutoring or counseling or access to funding for college courses, vocational programming such as barbering or CDL licenses to drive trucks once their detention ends. So in short, education for students who are incarcerated, correctional education, is so very important to kind of thinking about next steps for these young people. And with the way that our clients have been denied that right to their education during this time since the pandemic begun until now, with the services that they're still not receiving, we feel very strongly, and as do our clients, that this is a gross injustice that needed to be taken on. And so together we took it on.
Thank you, Taya. Caitlin, can you share with us some of the wins that the team has experienced thus far?
Absolutely. And so glad to be here and to be talking about this really important case. So the team, as we mentioned, filed litigation against the district in April of 2020 to address what was really serious deprivations of educational rights on behalf of the students who were attending the school at the DC jail. And along with that complaint, we filed a motion for preliminary injunction so that we could get immediate relief. As we all know, cases can take a really long time to wind themselves through federal court. And we knew that for our clients, waiting until the end of that litigation would be meaningless relief, even if they won. And so it was really important to make sure that we sought preliminary relief to make sure that students could immediately access their education and that the district would be forced to start providing that education again. And so then in June of 2021, we got an order from Judge Nichols of the DC District Court that ordered the district to begin to provide education, full hours of special education and related services within 15 days of his order. And at that point, the jail, lots of parts were still on lockdown and the pandemic was still on everybody's mind. And so the judge made sure to specify that that education had to happen synchronously, like students had to be able to meet with their teachers and talk to their teachers, but it could be done via video conference or in person. And importantly, the judge also required the district to start tracking how it was implementing students' IEPs and how much education was being provided to students and reporting that to the judge on a monthly basis to make sure that they were living up to the preliminary injunction. Unfortunately, what we found after observing the reports from the district is that they were not always complying with students' IEPs or delivering the education. And so with the team, we were able to file a motion for contempt, showing that the district did not live up to the preliminary injunction, did not do everything it was supposed to do. And then we're granted relief on that motion for contempt, which allowed students to access some extra tutoring and supports that will help ensure that they get the services they need immediately. One of the things that was so important about that contempt order is that the students who are in the jail or who've been released from the jail are trying to earn their high school diplomas, are trying to get the education that they deserve. And after being denied education for so long, really need those supports, as Teo mentioned, in order to access their education and achieve everything that they want to achieve. And so that order allowed them to access some supplemental services to make up for the fact that the district failed to provide them even after the judge ordered them to do so.
Thanks, Caitlin. Zenia, can you share with us the case posture? So sort of where are we now? What's coming up? All of that would be interesting.
Sure. Well, thank you for asking me to speak today. So the district is still subject to the preliminary injunction ordered by the court and that Caitlin just talked about. The district continues to report on a monthly basis the number of hours that each student is receiving as compared to the number of hours of education that student should receive as mandated in his IEP. And we're continuing to monitor the district's compliance with that preliminary injunction. The contempt relief also, which Caitlin just spoke about, is in the process of being rolled out to the students at the DC jail, to students in the community, and to students who've been transferred to other correctional facilities. So while the students are currently receiving some relief, relief through the preliminary injunction and the contempt relief that's been ordered by the court, the merits of the case haven't been decided yet, and we're still in the initial phase of litigation since discovery hasn't begun. And currently there are some critical motions that are pending before the court, including our motion for class certification, the district's motion for partial dismissal of all but one of our claims. And after that is decided, the district will finally file its answer to our complaint. And, we also have several other motions concerning the scope and the manner of the relief already awarded by the court. So we're awaiting a decision on those motions any day now, which, will very much inform what happens next.
Thank you. So you guys have all mentioned a little bit about the impact. I'd like to dig deeper into the impact, both sort of at the individual client level, but also sort of larger and more systemically. Teo, can you talk a little bit about the impact at the client level, sort of what changes have happened during the case and how your clients are doing now?
Yeah, absolutely. So for the named plaintiffs, who we all filed under pseudonym, they feel very empowered by this case. They were all, I should say from the very beginning, very, very willing to jump in and, help us litigate this case, help us understand the issues, give their time when they, obviously have a myriad of things happening in their own lives that could have otherwise taken precedence. They have all put this case front and center. And, for that, we're so grateful to them and, all the insight that they've provided us. Usually for most students clients we have at SJP, correctional education can feel very hopeless. Oftentimes these are the students who are left behind, but who have also been left behind for a number of years. This case has actually let the students know that people care, that people are watching out for their interests, that people are learning about how they've been treated under this circumstance, and particularly, given the pandemic. And even that a federal judge has said that what has happened with them is not okay, that they are entitled to these special education protections, that they need to be given these access to their instruction and their services. And, even as, both of my colleagues have pointed out, even when, the relief has been awarded and the students haven't been given that relief, the federal judge has come back a number of times now and said, the students are still entitled to these protections. Let's make sure that they're getting them. And why are they not getting what they deserved? So for the criminal court cases in which, some of the clients are involved, I will say that the judges in their individual cases have also been very impressed by the named plaintiffs' efforts, to move the case forward for those cases that we've presented the information that they are involved in this litigation under pseudonym and sealed filings, of course. The Superior Court judges have seen that as a sign of maturity and that the young people are taking control of their futures, which is very important when you're thinking about judges considering things like the Youth Rehabilitation Act or the YRA, and it's and whether a young person should be considered for that set aside. So, by and large, we've just seen an increase in the student participation with their schoolwork. The students are more engaged in, attending their counseling sessions because they know that, we're all fighting so hard for them and they're all fighting so hard to make this happen as well. And, we've even seen significant increase in the number of students who are reaching out to us throughout the class, those that we don't know personally, to ask about their awards. When am I going to get my tutoring? When am I going to get my counseling? I mean, they're engaged. They're really excited that this is happening, and we're excited that that we can do this for them.
That's great. And so taking a step back, Caitlin, I'd love to hear your thoughts on this. Sort of what's the sort of national landscape impact? I'd love to hear about how this is affecting the larger field. Are other jurisdictions looking at cases or similar issues to this? And if so, how's our litigation team collaborating?
Absolutely. So I think this case is really important on a national level for a couple of different reasons. The first is that these problems were not unique to the DC jail. Across the country, students who were incarcerated were having trouble accessing their education because of the COVID pandemic and during the COVID pandemic, but frankly, sometimes even before that. And so any litigation that looks at the rights of young people who are incarcerated to receive their education sets important precedent around the country. Particularly, though, this case was one of the first federal cases that was brought to enforce students' rights to special education and related services during the COVID pandemic. And so that is also another really important aspect of this case, to start to define how school systems were interpreting special education law during the COVID pandemic, what their obligations are during an ongoing health emergency like COVID, and how they may be required to compensate for the failures to provide education during that time. Something that I think is really exciting about this case, it was also an opportunity for the Department of Justice to file a statement of interest where they explained what their view is on school districts' obligations and made really clear that just because the COVID pandemic was happening did not mean that schools were excused from complying with the IDEA. And that was true in the community, and it was true for our clients who were incarcerated during the time. We also know around the country that as attorneys and community groups and individuals are facing this kind of denial of services and discrimination in accessing their education, that people are working to try to address that and contemplating litigation, I think, that looks like ours. And we've been really happy as a team to be able to share our expertise and to work with other teams of advocates across the country who are thinking about how to use litigation to address these really long-standing problems and providing a high-quality education to students who are incarcerated.
Thank you. And on the topic of collaboration, just sort of looking a little bit internally, Xenia, can you share a little bit about what it's been like collaborating on this case together? We have our two organizations and the law firm working together on this case for a very long time. What has that actually looked like?
Sure. Well, I think the collaboration among our three organizations has been incredibly productive. Each of our organizations, brings unique perspective and added value to the group. And we meet regularly, very regularly, on a weekly basis to discuss strategy, to assess, where we are in the case and make decisions about how we move forward. And the team, also takes a collaborative approach to drafting and reviewing briefs, motions, anything that's really filed in court. Our law firm drafts the initial documents, and then School Justice Project and Washington Lawyers Committee reviews, edits, and provides really important feedback, based on their unique knowledge of education and the carceral system. And our review turnaround times are often pretty tight. And, I've been very impressed with everyone's willingness and commitment to dedicating the time, to make sure that our work product is the best that it can be, that it's persuasive. I think the judge has agreed with that. And, we also conduct moot courts of each other to prepare for oral arguments. And all three organizations are actively monitoring the implementation of the contempt relief ordered by the court and the preliminary injunction as well, to make sure that, the students are heard, that they receive the makeup hours and services that they need. So we're all collaborating on equal footing. And so overall, I would say that, while there may be a little bit more work in having three organizations work together, working as a team, has really strengthened our case, because There's always somebody that is thinking about every angle of the case and making sure that nothing slips. I have to say that we all get along really well and we respect each other's opinions. And that, of course, makes working together a pleasure.
That's great. So we're reaching the end of our time. Teo, I would love to hear from you sort of what's the impacts, the overall impact that you're hoping that this case will have on correctional education in the district.
Yeah, sure. So, even though this case was initiated during the pandemic, as Caitlin mentioned, the issues that we saw were really an outgrowth of pre-pandemic conditions. We're hoping that this case changes education at the DC jail for the future, not just to address the violations that have occurred during the pandemic that are limited to that time frame, but some of these bigger questions that we've seen for so many years at SJP. So for instance, we want to see quality special education for students, meaning we want to see regular daily access to classes for students in person, as well as their related services. And I understand that seems like a very minor ask, but it's not. Unfortunately, by and large, we have seen over the years students not being able to access their classes because a correctional officer didn't call them for their class or wouldn't allow them to go to their class. Of course, there are the rare situations like, during this time, of course, the quarantine that might happen. That might mean that a student might not be able to go to their classes in person. But even so, then synchronous virtual options should exist. And now because of our litigation, they do exist, but they didn't beforehand. We want to see less students move to restrictive housing units, or in the hole. And when they are in those restrictive housing units, we want to see continued access to education. Again, not just, virtual education, but we would love to see them brought down to the classes. And there's so many different ways in which the Department of Corrections could work to think about how to prioritize their safety concerns, but also meet the needs of the students educationally that they are entitled to under law. We do want to see access to compensatory services actually happening. For the students that were part of this lawsuit, they have been awarded some services at this point. But the biggest hurdle is just getting the district to allow the providers even into the facilities on a regular basis so that they can take advantage of these awards that they've now won. But even outside of that context, in the future, for students who have, let's say, a counseling service that they're entitled to, that they won through a compensatory service award, we would like to see the students being able to access that, long after this litigation has ended, without the types of major roadblocks that we've seen during this litigation and even before. We want to see overall a change of attitude, I think, by the district in terms of the access that special education students have to their education, specifically thinking that education should be used as a carrot for good behavior. Instead, we want to see folks thinking that education is a legal right that these students have under federal and local law, and that it should not be denied to them because of either logistics or because folks don't think it's important for them to access the education that they are entitled to. I think that this case has already helped, hopefully, in that manner to kind of start some of that mindset change. But there's certainly a lot more work that needs to be done. And, until then, obviously, we will continue fighting to ensure that that happens.
Well, thank you all so much for talking about this important case. I know we're all hoping to see continued sustainable and significant change. for access to education for court-involved students with disabilities. So thank you all for being here, and thank you for sharing about your work. At this point, I will turn things over to SJP's board member, Dave Bly.
Hello, everyone. What an engaging discussion. Thank you to all of today's amazing panelists. We'd like to again thank our sponsors of the event, in particular our platinum sponsors, Alex Partners, our host, the Russo-Thompson family, Halo Top International, and Venable. Please check out the SJP website to learn more about this incredible team of supporters. We'd also like to thank our individual leaders of the event shown here on the screen. And last but not least, thank you to all of our attendees. SJP would not be able to impact the lives of so many without your support and the interest you've shown today by attending to learn more. With that said, SJP would not be able to make such an important impact without your financial support. Every dollar donated will go directly towards making a difference for DC's older court-involved students. To support SJP and ensure they can continue their mission, please visit our website at sjpdc.org. Thank you again, everyone, and have a great day.